Hi, my name is Darryl Biggar. I'm an economist with the Australian Competition and Consumer Commission, and I'm delighted to be with you today speaking about line of business restrictions. This is an issue that Working Party 2 has been involved in a lot in the past and has contributed both on the research and the policy. I should say at the outset that these views are expressed here are my own and not necessarily the views of the ACCC or the AER. The topic today, as you know, is line of business restrictions. A line of business restrictions says to a firm that's involved in providing service A that you can't provide service B or vice versa. Most firms in the economy, of course, are free to choose how they organise their businesses. And the question for us is why? Why would we impose line of business restrictions? What purpose do they serve? To answer this question, we have to go back to the economic foundation of competition law. The standard textbook approach to competition law focuses on the economic harm known as deadweight loss. But I have several concerns about that theory, and I think it doesn't apply very well in this context. I'm going to adopt a slightly different framework today that has emerged in recent years. This framework focuses on the need for investments. Almost all ongoing transactions in the economy require sunk investments by one or both parties. And these investments are subject to the threat of hold-up, the threat that once the investment's been made, that the other trading partner will change the terms and conditions of trade, taking away the value of that investment. So according to this perspective, the role of competition law is partially to protect and promote these investments. So, for example, an airline might need to invest in marketing and promotion to develop a new route to or from a particular airport. Or an electricity generator might need to invest in physical assets in reliance upon access to the local electricity grid. Or perhaps a small manufacturer of a product which is sold in Amazon's marketplace might invest in research or development of a new product. Or perhaps an app developer must invest in developing an app which is sold on Apple's App Store. Now, in a competitive market, these investments are not specific to any one particular trading partner. So if the trading partner tries to engage in hold-up, then the counterparty can simply switch to another party to trade with. But this is not the case in markets or in supply chains which have a dominant or a bottleneck firm. In this case, the trading partners may not be able to take their business elsewhere without substantial loss of value. In these cases, there is a substantial threat of hold-up, and the trading partners, upstream or downstream, may be reluctant to invest unless they get assurance that some protection from this threat of hold-up. And according to this perspective, competition law steps in to provide a degree of protection of this sunk investment, so as to encourage investment, so as to encourage competition and economic welfare upstream or downstream. I think this framework applies quite well in the context of line of business restrictions. So let's now look at that. Let's imagine that we have a firm in a supply chain which is in a dominant or a bottleneck position. In my view, these terms of dominant or bottleneck position are equivalent to saying that the firm is in a position to engage in hold-up of its upstream or downstream trading partners. Now, a firm which is in a dominant or bottleneck position is often under various controls by competition law, such as it controls on the ability to raise the price, to withdraw service, or to price discriminate. And in addition, in the context of a firm in a supply chain, they may be in a position to expropriate investments upstream or downstream by, for example, discriminating in their treatment of firms upstream or downstream on their prices, terms and conditions, perhaps discriminating in the way they make or fail to make necessary complementary investments, or perhaps they could engage in misuse of information, using the information they gain from their position as owner of the bottleneck or monopoly facility to favour firms upstream or downstream. So in a supply chain which has a monopoly or bottleneck firm, the firms upstream or downstream will almost always require some sort of assurance that they will be fairly treated before making their investments. In this context, vertical integration between the monopoly or bottleneck firm and a firm upstream or downstream converts the arm's length inter-firm transactions into intra-firm transactions, and therefore reduces transparency, making it much harder to detect discriminatory treatment or misuse of information, which could have a chilling effect on investment upstream or downstream. So the advantage of line of business restrictions is that they enhance the transparency of the monopolist dealing with firms in the upstream or the downstream market. They enhance that transparency, making it easier to discover and to detect and to prevent discriminatory treatment or misuse of information, and therefore make it easier to provide an assurance to firms who are thinking about investing upstream or downstream that they will be treated in a fair and non-discriminatory way. So, for example, you might consider the following thought experiment. Do you think that if an electricity network owned its own electricity generator, that other independent electricity generators could be assured that they will receive equal treatment and access to the network in regards to operation and maintenance of the network, or perhaps in decisions regarding upgrading of the network? Or what about an airport which also owned an airline? Would rival airlines be concerned that the airport would favour its own affiliate, perhaps in access to gates, perhaps in priority on the runways, perhaps in getting the best takeoff and landing slots? If Google also provided certain apps on its app store, would a rival app developer be concerned that Google would preference its own apps, favouring them in, for example, the degree of promotion, and so on? So to prevent this, we often impose line of business restrictions, and there are several examples that we can point to. I've already pointed to an example in the air transport industry, where in Australia at least airports are not allowed to own more than 5% of the shares of airlines. As I've said, in the electricity sector, it's quite common for electricity networks to be prohibited from providing electricity generation services or electricity retailing, for exactly the same reason that it provides other firms considering investing in electricity generation or in electricity retailing that they will receive non-discriminatory treatment. In the telecommunications sector, there's been ongoing concerns about integration between content providers and infrastructure providers, and there the concern is that the bottleneck infrastructure provider will favour its own content services to the detriment of other content providers, thereby reducing the incentives for investment in the related content services. I should mention that there are other forms of separation as well, which Working Party 2 has looked at in the past, including accounting separation, legal separation, corporate separation, and so on. Now, these forms of separation can enhance transparency of the transactions between the monopoly or bottleneck firm and its affiliate. And perhaps this could help, but I remain concerned that these forms of separation do not remove the incentive of the monopoly or bottleneck firm to favour its affiliate. And therefore, they don't provide the same degree of assurance to other potential entrants that they'll be treated in a fair and non-discriminatory manner. There can be other solutions to the hold-up problem as well. In some sectors, the upstream firms jointly own the monopoly or bottleneck service. By jointly owning the bottleneck asset, they can ensure that they each get non-discriminatory access. Such arrangements, such joint ownership or cooperative arrangements occur, for example, in the agricultural sector and also in electricity. I should also mention that there can be significant benefits from vertical integration. perhaps on the cost side in the form of more efficient provision of services, or on the demand side in the sense of more innovative services that customers desire. And these benefits from integration have to be traded off against the potential costs and harms to competition. In recent years, these concerns of the effects of integration and the potential for line of business restrictions have arisen particularly in the context of online digital platforms. For example, we can ask ourselves, can a seller of products on Amazon's marketplace be assured that it will get equal promotion and protection from, say, counterfeit products as Amazon's own products? Can producers of best-selling products be assured that Amazon will not use the information that it gains about sales to design its own rival products? A few years ago, Bloomberg published an article with the headline, "Got a hot seller on Amazon? Prepare for the e-tailer to make one too." Similar concerns have been raised about the position of Google or Apple in the provision of apps. Here the concern is that the developer of a successful app might find that Google or Apple develops a rival app itself and perhaps better promotes that app or has it better integrated into the Google or Apple ecosystem. These concerns were raised, for example, by Lena Khan, and she puts the following quote in her paper. Quote, "Venture capitalists now factor this risk into their investment decisions. Venture capitalists now discuss a kill zone around digital giants, areas not worth operating or investing in since defeat is guaranteed." In my view, that quote expresses very well the concern about potential investors in the upstream or downstream markets, that the value of their investments might be expropriated, which has a chilling effect on investment and therefore on competition. So where does that leave us? Line of business restrictions, in my view, form part of a broader set of restrictions on firms which have material market power, that is, are in a position to engage in hold-up of their trading partners. If you have a bottleneck or monopoly firm in a supply chain, it can engage in hold-up by dealing with the upstream or downstream firms on different terms and conditions, by not making complementary investments, or by misusing information that it gains. In order to have investment upstream or downstream, the firms that are considering making that investment need an assurance that this sort of misuse of information or discriminatory behavior is not going to occur. Vertical integration, by turning arm's length transactions into internal intra-firm transactions, makes the detection and prevention of such discrimination and misuse of information harder, and therefore undermines the ability to provide an assurance to businesses upstream or downstream. For this reason, in many sectors, particularly public utility sectors, we regularly require structural separation. That is a requirement that a firm engaged in the bottleneck or monopoly service not also be involved upstream or downstream. There are other solutions, such as joint ownership of the monopoly or bottleneck, that are used in other sectors, particularly agriculture. As we've noted, these issues have been applied recently in the digital platform sector, where some digital platforms appear to play a bottleneck or gatekeeper role in some markets, and there are increasing calls to impose line of business restrictions. That's all. I hope you have an interesting discussion. Thank you for listening.